I think we need, as we think about the legal framework that governs all of this, to keep our eyes on the prize. And Cassie is going to talk about linking enormous data sets held by the public, including census, education data, income data, and looking at all of that in relation to the NHS and what an important and incredibly powerful tool that is going to be to improve the public health. And not just in the UK, I think possibly more broadly, as you said, with the recovery trial. I mean, this could be a global endeavour. But the legal challenges are not, and I did have the honour of temporarily being the DPO at Our Future Health before the recruitment effort found Constantinos. And it was very, very, very interesting period, I can assure you. But the legal challenges I didn't find insurmountable. And I didn't find the legal challenges when I was working for the ICO during the pandemic, and I was sent on a secondment, virtual secondment, into NHS-X, so information governance team within the NHS, to help them think about the mass health surveillance implications on data protection, privacy, all of those good things. Again, the legal challenges weren't, I didn't find, insurmountable, but they did require, in the end, the COPI notices, because there was an outcry of trust. People were concerned, and that led to, particularly the GPs, in our experience, getting nervous and saying, well, I'm not going to give you, as the controller of the data, I'm not going to give you access to my patients' data, irrespective of whether or not those particular patients had exercised their right to opt out, which was eventually overridden by the COPI notices, by a legal mechanism that was obviously debated in Parliament at quite some length. So there was transparency. Those debates were publicly available. People, the MPs, got to vote on them. But the aspect that was interesting was that without the data from GPs in certain postcodes of certain cities in the UK, which probably represented minority groups more than other postcodes, for example, that was the data that was really, really valuable, because the research tended to show that people of those ethnicities were more likely to die than not if they did contract the disease. So accessing that data was so important to helping the health outcomes of those particular minority groupings, and those minority groupings were the ones who were more nervous potentially about having their data used in this way, and certainly the guardians of those data, the GPs. It was patchy. Some of them understood and would give access as a controller, and others simply wouldn't. So while at the ICO, the Ben Goldacre review, I don't know if you're familiar with that, was undertaken, and obviously the ICO was asked to comment on that. And again, we didn't find that the barriers to effective research, which I think Alison and Cassie are going to make clear to you, are necessarily, for once, the GDPR and the Data Protection Act's fault, I'll use that word, because we were able to say, if you dig around the recitals of the GDPR, it actually uses the word pandemic, and we've got a basis for cross-border health processing. So we felt on fairly firm ground in terms of legally, all of this is possible. Where you may struggle is common law confidentiality, the duty of confidentiality between you and the doctor and the GP, and the Human Rights Act, people's right to privacy, which we've been hearing about how nervous people were when they understood that their GB data may be analysed in that fashion, even though it was anonymised and encrypted. There is still, so to my mind, legally, done. But within the wider environment, people are still very nervous when we talk about anonymisation and encryption. So that leads me neatly onto the ICO's guidance on anonymisation and pseudonymisation, which again, I read a draft that was sent out for consultation. I think you said that draft has disappeared potentially off the website. I've downloaded it very sensibly, so I've still got a copy. But I think they were substantially rethinking their guidance in this area. But it did introduce a concept that I found super helpful, although possibly not legally, not having a legal basis, of effectively anonymous. So we've got directly identifiable, pseudonymous, and then effectively anonymous, and then anonymous, true anonymity, which, as we all know, is quite difficult to achieve. So that then raises the question of effectively anonymous in whose hands. There's a case with Deloitte's in the ECJ, but also when I was working at Our Future Health, who run a trusted research environment, in terms of controller-to-controller data sharing, I felt quite strongly that actually the data were effectively anonymous in the researchers' hands because only I had the key, they were encrypted, they weren't going to get the key, they had no legal recourse to the key, they would never have the key, effective anonymity. And I think, to be fair, Our Future Health went through the sandbox with the ICO and different conclusions may have been reached. The bill, oh, crikey. Oh, God, what a mess. So I was personally very, very relieved it didn't pass and that was not part of the wash-up. And its attempts to try and help in this area, and as I've said, I don't find the legal framework to be a barrier. I think there are other elements that are more pressing, as I think Alison and Cassie will demonstrate, than the sheer the legality of it. And what the bill attempted to do, I have to say, it was a little bit like one of those magic eye pictures. If you looked at it and let your brain go slack, you could kind of see it vanishingly quickly, what was happening, and then it would be gone in an instant. So, again, I think that would have hurt and not helped efforts to streamline this area. And so I'm quite relieved it didn't pass because we need clarity and convergence, and I don't think the bill was going to deliver that.